President Joe Biden signed the National Defense Authorization Act for fiscal year 2023. That includes legislation on unidentified anomalous phenomenon. Daniel Sheehan, a lawyer specializing in constitutional and public interest matters, analyzes the recent passed National Defense Authorization Act legislation with me. He sheds light on the difficulties, loopholes, and ambiguous language presented in Section 776 of the bill, while also addressing the lack of reporting mechanisms within it. Additionally, he discusses the activities of whistleblowers and shares his insights on Sean Kirkpatrick's recent hearing and involvement with AARO. Join us as we get rebelliously curious. Danny, thank you so much for joining me on Rebelliously Curious. For the longest period of time, I've always wanted to talk to you. You know so much about legislation. You've done so much work in civil rights. It's unbelievable. And I've been following your career for a very long time and was very lucky and had the pleasure to meet you about a couple months ago. And also just talk not just about UAPs, but just about your civil rights work that you've been doing. So thank you for agreeing to be on the show today.
Terrific. I appreciate it.
So let's start off. How did you get into the UAP topic? And can you explain to people what you do within the UAP topic as well, too?
Sure. Actually, my official involvement in it began when I was general. Whoops, sorry, I better turn this off. When I was general counsel at the United States Jesuit headquarters in Washington, D.C., in their National Social Ministry office back in 1975. I was there for a decade, from 75 to 85. I was a candidate for the Jesuit priesthood at that time. I had gotten recruited out of Harvard Divinity School after finishing Harvard Law School, Harvard College, and I was down there. And I was contacted shortly after President Jimmy Carter was elected in November of 1977. I was contacted by Marcia Smith, who was the head of the Congressional Research Service, Science and Technology Division, and they had been asked by President Carter to do two major studies. One of what the chances are of there being extraterrestrial intelligence here in our galaxy, and the other one was there, what relationship might there be between extraterrestrial intelligence and the UFO phenomenon? Because as you probably know, and most of your listeners know, that President Carter had actually seen a UFO when he was governor of Georgia. Not like a little light in the sky, but like a regular flying saucer. He had seen it. And so when he had gotten elected in November of 1976, he immediately contacted the head of the Central Intelligence Agency and asked to be briefed on all the UFO information that they had. And they directed him to the Office of Congressional Research to be able to compile studies for him. And I was contacted by Marcia Smith, who was the head of the Science and Technology Division of the Library of Congress, their Congressional Research Service, and asked if I, as legal counsel for the Jesuit order in Washington, D.C., would contact the Vatican and see if we could get access to whatever information the Vatican might have in the archives about UFO sightings and potential extraterrestrial intelligence. And so I checked with my superior, Father William Davis, and with the assistant provincials throughout the United States to get permission to do this, and they agreed to have us do that. So we contacted the Vatican, and unfortunately, the Vatican refused to allow us to have access to the information. But I remained as special counsel to the study, and was invited to deliver a closed-door 3-hour seminar to the head scientists at the Jet Propulsion Laboratory at the SETI program out in Pasadena, to go and deliver a closed-door seminar on the theological implications of contact with an extraterrestrial civilization. So that's how I got involved in it originally, back in the spring of 1977. And that's why I was contacted later in 1994 by Professor John Mack at Harvard University. He asked me to represent him when he was dragged up in front of a tribunal, a faculty tribunal in 1994, because he had written a book about the phenomenon. And then that's why I was asked to be legal counsel for the Disclosure Project by Dr. Stephen Greer in 2001, and then later became legal counsel for the citizens' hearings on the UFO phenomenon with Steve Bassett in 2013. And for all of those reasons, I was contacted by Lou Elizondo after he and Chris Mellon provided the videotapes to the New York Times that were published on December 16th and 17th of 2017. And Lou asked me to be his legal counsel to protect his security clearances, et cetera, and to work with him at his objective, and the objective of Chris Mellon and others at the time, to try to secure as much information as they could to be released to Congress, to the Senate and House Intelligence Committees specifically, everything that was known by the U.S. military services and the intelligence agencies and Defense Department, and very importantly, the military contractors, corporate contractors with the military, that anything that they had discovered about the UFO phenomenon, dating all the way back to January of 1945. So I've been involved in that process, and still am.
So unbelievable. And so many tall orders too for such a long period of time. Like, yeah. And so much responsibility, really, and on the legal side of things and the implications of it, because right now we move into a space where legal implications are very serious with whistleblowers, the conversation of many whistleblowers coming forward, potentially obviously going on the record with the government, and then obviously coming forward, hopefully maybe publicly, where we'll speak, we'll learn a little bit more about what they've been experiencing. But back to the conversation of like legal, we have the National Defense Authorization Act of 2023. And there, as you know, and as everybody else knows that follows this topic, there is some amazing wording within this bill. Can we break down a little bit of the legislation together and just, not by line, but talk about from the lexicon that's put in there and the lexicon that they're building within government, from words that we use like crash retrieval, reverse engineering. The government does use that, not just in a UAP context. But can we talk a little bit about the implications of this and then what it actually means for the average person who might not understand the legislation jargon?
Yeah, for sure. I'd be happy to do that.
So what is secure methods and what is secure reporting in context to this bill?
Well, it's interesting, Chrissy, because the Senate and the House both passed separate bills to try to establish this new office. The Senate passed a Senate Bill 4503 that was very aggressive and got into great detail and was very forward leaning, actually. That to demand that this office that they were setting up, a joint office, it was called in that bill, in the Senate bill, it was called the Unidentified Aerospace and Undersea Phenomenon Joint Program Office. But it was very complicated. You couldn't quite dance to that. They couldn't figure out any kind of a short name for it, but that's what it was. And in that bill, they actually demanded, there was some 84 different tasks that were assigned to this new office, this new joint program office, as they were calling it. And one of them was that they were to take aggressive steps to protect any of the people in the military services or in the intelligence agencies or in military contractors that wanted to come forward and share this information with in that case, the Senate Intelligence Committee. The original bill had a provision in it that said that anybody in position of being inside one of the military services or the intelligence services or Defense Department or these contractors who had signed a non-disclosure agreement or were subject to national security clearances would have to be first interviewed by the FBI before they could come forward. And when I found out about that, having 50 years of experience in dealing with the FBI, I thought that was a real bad idea. FBI guys tend to be pretty tight about what they allow done. So the bottom line is, we got that part removed from the Senate bill. They didn't have to get cleared by the FBI to do this. And that bill also had in it an extraordinarily important provision that if anybody tried to retaliate against a person who was trying to come forward and provide information to the Senate Intelligence Committee, that would generate a legal cause of action that the victim of such an attack would have against the person who did it, no matter where they were inside the government, that they would have a legal cause of action in a court of law, in the federal district court, could bring an action. Now, when I saw that, I just said, no, that's the key to this thing. If they know that they're going to get a legal cause of action against them personally for trying to interfere with any person or retaliate against any person who came forward to try to give information to this new office, this new joint program office, that really constituted teeth, in a bill like that. And so that those of us who were in communication with the staff at the Senate Intelligence Committee were extremely supportive of such a provision, right? And they also had in the language the various senators would put additional pieces into the legislation, saying, okay, we want to make sure that the information that needs to be divulged to this committee includes any effort to retrieve any UAP craft of any kind, and would have to include any effort to re-engineer or back engineer any of this technology. And the senators would kind of come in and they would hang another one of these, they call them these little ornaments on the Christmas tree. They would hang another one in there to demonstrate their familiarity with this whole field and how important it was to kind of push the executive branch officials into the corner, to not give them any leeway on this. And so this Senate bill 4503 was this ideal bill that was very forward-leaning, very aggressive, set up the office for unidentified aerial and undersea phenomenon, and was very forward-leaning to solicit this information. Now, what happened is it went over to the House side. And when it went over to the House side, a series of kind of peculiar things started to happen. That's important for people if they want to follow the intricacies of this. There was a more resistant response on the part of the House members, that they were being lobbied by the executive branch. There wasn't any doubt about it. And by the military and the CIA and the others who had kept secret this information for like 75 years. And so that they leaned in on the House members. And the first thing that happened was a change in terminology. Rather than focusing the investigation and the activities of this new office on the unidentified aerial or aerospace and undersea phenomenon, they changed the name of it to anomalous phenomena. That they wanted to investigate all kinds of anomalous phenomena, and that and so that all of a sudden that rang all kinds of bells for me and put up big red flags, because that if you have a time limitation, there's a 4-year time limitation on the expiration of this office. there's a sunset clause basically on this office, that this was got put in there to say that you got 4 years to basically try to get this information and get it turned over to the Senate and the House Intelligence Committees and Defense Committees. Now that's a thing. Those of us who've been in Washington for 20 years or more, we know right away what that's for. That is to kind of give the signal to the people that don't want to comply with this congressional mandate, the time to drag their heels on this thing and drag it out and hope to run the clock out on this thing. So that was an unfortunate provision that got inserted. Was this sunset clause on the life term of the office. And secondly, I said that they expanded the phenomenon to be looked at from just the phenomenon of the aerospace and undersea unidentified phenomena into anomalous phenomena. And you couldn't quite tell what all that included. But those of us who were familiar with this thought that it included all kinds of peripheral issues to the classic UFO issue. And so a lot of time could be misspent looking at those things and kind of avoiding having to deal with the UFO issue, like things like the Skinwalker Ranch and ghost phenomena and, communication with the dead. There's all kinds of these weird anomalous phenomena that occur
Right.
inside.
They just lumped everything together as one.
They just lumped it all together like that.
Yeah, it's a loophole in its own way. Yeah,
in its own weird way.
Yeah.
And then they named the office instead of the Aerospace and Underwater Unidentified Phenomenon Joint Program Office. They changed the office to the All Domain Anomaly Resolution Office, which they could then call AARO, so that they had a nickname that they could use. But at the same time, it indicated that they were going to be leaning toward resolving all of these issues, right? And so that rather than investigate them, they seem to be leaning much toward, in a sense, dismissing as many of these things as they could, resolving them. Oh, this was a flock of birds. This was a searchlight reflecting off from clouds. And we went through that experience with Project Blue Book,
right? Many times,
back
yeah.
in the late 50s and 60s, and so that whole boogeyman started to raise its head again. This is indications of the fact that element that's been trying to keep this stuff secret all this time is now having its way here with this new bill that's coming out of the House side. And so that's something that we've been concerned about, the watering down of the kind of ideal Senate bill 4503 into this other bill, which was the House Resolution 7776, that actually ended up being the bill that got put into the National Defense Authorization Act. Right. So what I did is said that, look, one of the things we need to do is the citizens who are all interested in trying to get as much of this information as possible conveyed to the Congress. We thought that we have to create a 501c3 public interest citizens organization to, in a sense, ride herd on this bill, to monitor how effectively the House and Senate Intelligence Committees and Defense Committees are making the office do its job, and then see how effectively the office, the new AARO office, is doing at making the military services cough up this information. The intelligence community was going to be the hardest, of course. The intelligence community, will classify the size of your shoes if they can get away with it. They're just obsessive about making everything secret because they view secrecy, information, as power, right, in Washington and in the world. And so that they think if they uniquely possess the information, they're in a position of power. And it's a certain affliction that our intelligence community has since the creation of the national security state back in 1947. And it's become kind of a major problem major public policy problem that those of us that have been involved in this area for 50 years are aware of. And so that the new law that has actually been passed, which was House Bill 7776 into the National Defense Authorization Act, is less than what we had hoped for. It was vaguer. It had a time limitation on it. It had all these different changes that I've outlined from the original Senate bill. So what we've done is we've set up a thing called the New Paradigm Institute. It's 501c3 public interest group that people can send information to, can send contributions to help fund what it is that we're doing. And I'm in discussion with a lot of the people that have been involved in getting the Senate bill passed to try to basically utilize the Senate bill that was passed as the real template for what we're doing and what we think ought to be done. We're not going to say, okay, look, so that they've compromised with the House side, so we're all going to accept that compromise. We citizens don't have to accept that compromise. We know that we've persuaded the Senate, the entire Senate, to support us in getting a much more aggressive, forward-leaning type of operation going here. And so that we're going to insist upon having those standards met. And so I'm in dialogue with a lot of the people that were formerly inside the U.S. government that were working on this particular set of programs, with Lou Elizondo and Chris Mellon and Dave Garouche and Carl Nell. There's a whole bunch of different people that have been involved in this, and we're involved in getting the Senate bill passed. And so we're all in dialogue now about mounting up this and standing up this UFO C3, basically, the New Paradigm Institute. It's a citizens group, and to work with all of the other citizens groups, MUFON and all the other groups that have existed, to try to focus in a special way on getting the information conveyed to the Senate Intelligence Committee. Okay.
Yeah, it's like the people governing the government in specifically in this specific section for transparency and understanding it. And I commend you on that, because I do think we need it. We obviously do. Can I ask you a question back though to like the reporting side of it? You said like there was a little bit of the fundamentals in there. There's one section that does say that after a whistleblower decides to come forward and speak on the record about their experiences, that then there's a 72-hour clause that then jumps into, I believe, to go to Congress, or if it's one of the other committees, but it's 72 hours. What activates that 72 hours? Because we've seen hearings now with Sean Kirkpatrick, but we've had, I believe, from what I know, there's been more than 11 whistleblowers that have come forward. Who knows now to date? But what activates that 72 hours? And then at the end of that, I believe that once that 72 hours is activated, then all the information is sent in to Congress. The president then actually does know as well. I believe he's the last one to know in this, and then he will sign off on that. I believe if it's confidential or not. You are the lawyer in this. I am not a legislation person whatsoever, but I want to clarify those two things of the 72 hours, but then also the president always knowing what is happening, especially with whistleblowers and what's happening around the UAP topic.
Well, one of the important, the extremely important things to keep in mind here is that this statute that was passed by Congress on December 23rd of 2022, this National Defense Authorization Act that had these provisions in it, 703, et cetera. The problem is that it's not clear at all what the enforcement mechanism is.
Exactly. You're right.
So
there's
whatever,
reporting, how they will report things, but then after that, it's very vague.
That's right. And so the bottom line is, for example, that we were very active. I was very active at the Jesuit headquarters when the United States Congress back in 1984 passed the law prohibiting any of the intelligence communities and the military, et cetera, to be giving any aid, either direct or indirect, to the Contras, the Nicaraguan dictatorial forces that were ousted from in South America. in Central America. And the problem was that the Congress commanded them to have no involvement in supporting the Contras, but there was no enforcement mechanism. And so the executive branch people and the CIA and the others just went around it and began to do it secretly. The same thing happened with the Indian Child Welfare Act, for example, that was passed in 1976. It mandated that the states stop taking Indian children away from their parents and placing them in all white schools, like in a continuation of like the boarding schools that they used to have. But there was no enforcement mechanism. And so in both of those cases, our office, the Jesuit headquarters at that time we had created a thing called the Chrissy Institute, which was a 501c3 public interest law firm, basically. We brought legal actions in both of those cases to enforce these things and to bring the judiciary in to make the executive branch people comply with the congressional mandate. So in this particular case, we have the same problem. We have a whole series of these mandates that have been put in to even in the watered down statute on the House side, but it's not clear who's going to enforce this. And so this office that we're setting up, the New Paradigm Institute, is going to be focusing on that. And we're going to be dealing with finding out who the people are who have come and attempted to provide the information to the committee, to this new Joint Program Office. Has the program office reported it up to the Senate Intelligence Committee and House Intelligence like they're supposed to? Have they in fact notified the president if they want to try to reclassify something and to keep it completely secret? You know, what is the procedure for that? You know, that who's in charge of making that decision? And if they don't make the decision within 72 hours, then what happens? Okay, so there's an awful lot of the details and the enforcement
Very
of this.
vague. Right.
And that's one of the things that the New Paradigm Institute is going to be focusing on, and trying to get some kind of rules set up here, some sort of protocols set up in writing, so that they can be enforced in some way. Now, one of our problems is that nowhere in this entire statute, and this is something that we encountered, for example, with the Indian Child Welfare Act, nowhere are private citizens given any standing to bring any complaint that this law is not being complied with. You know, so if Congress runs off and is busy doing all kinds of other things, trying to deal with the debt ceiling or trying to deal with the military funding to the Ukraine or whatever they're doing, if they don't pay attention to this, you know, who's going to enforce it? And so that's one of the important roles that the New Paradigm Institute is going to play. We're going to be doing everything that we can do to make sure that particularly people inside the Senate Intelligence Committee are leaning into getting this thing enforced, and that they be promulgating written rules and regulations, guidelines, enforcement guidelines that could be implemented and put in place so that we have something that we can refer to as a supplement to the law, basically.
Have you given any of those examples? Are there any examples you can share with us as like a best practice you would say to them, like, this is what the people would want, or speaking on behalf of the people, this is what we feel a best practice would look like this within legislation? Do you put any, and what would those examples be?
Well, we for example, our office actually, with regard to the Indian Child Welfare Act that I was referring to, we drafted, the Justice Department came to us and asked us if we would draft them.
That's amazing.
So we did. We drafted like 100 guidelines, enforcement guidelines. That's what's triggered the major litigation that's in front of the United States Supreme Court right now. At the end of June, there's going to be a ruling by the United States Supreme Court because the American Academy of Adoption Attorneys were making $100,000 a piece on Indian children, you know, taking them from their families and putting them with wealthy white couples. You know, were all upset, and they filed a litigation to try to stop us from enforcing the law. So we've got some expertise in doing this kind of thing, putting together an entire cadre of rules and regulations about this. Now, what we're going to be doing is meeting with some of the people in the staff of the Senate Intelligence Committee on both sides. You know, Marco Rubio and Mark Warner's staff, who are focusing on this, who were involved in helping to draft it, to come up with a set of guidelines that they believe would be effective. We're trying to basically, as citizens, get the government agencies that are responsible here to do what it is they're supposed to do, rather than us having to do it all. So we're going to try to give them the opportunity to come forward with some, and if they don't, then we're going to come in, and we're going to say that, for example, when there needs to be a careful log kept of any person who contacts the office, the AARO office, of the exact time and date of their contact, an exact record of what the information is that they've been given, an exact record of who the person is who has demanded that information be kept secret. Okay, and what is the statutory basis for their demand for that secrecy? What provision would it fall under? Because they have this general thing. It's usually methods and means and method. Means and method by means of which we get information has to be protected. It's just like this big wet blanket they throw over everything. And we're going to say that's not sufficient. You can't just say that, you're going to cite some vague security requirement. It's got to be very specific. What is it that, for example, I was one of the legal counsel for the New York Times in the Pentagon Papers case. So I found myself in chambers with Judge Murray Gerfine, with the United States Attorney for the Southern District of New York, functioning for the Nixon administration, just saying, there's 47 volumes of the Pentagon Papers. If any of this information is released to the public, it'll cause irreparable damage to the national security of the United States. And so I said to him, like what? And he said, I'm sorry, we can't tell you because you don't have adequate security clearances. So Judge Gerfine said, well, how about me? How about telling me, if you're here trying to get an injunction against the New York Times for releasing this, you have to at least tell me what kind of irreparable damage you think is going to be imposed on the government of the United States. And the lawyer, Whitney North Seymour, said, well, I'm sorry, I can't tell you either, Your Honor, because you don't have adequate security clearances either. That kind of mindset, is a problem. So what we want to do is get people inside the Senate Intelligence Committee staff to be able to formulate some rules and regulations, detailed rules and regulations about what the protocol is to be followed here, what kind of record keeping is going to be required, that at least the Senate Intelligence Committee has to have transparent access to all of those records, so that to the extent to which that committee is interested in getting the law enforced, they will have a means of doing it. So that's where we're going to start, and that's where what we're working on now.
I can't wait until that goes forward. And I speak probably for everyone who watches this podcast and listens as well. I know people want that. Yes. They really do. When we're looking at the Atomic Energy Act from 1954 and the National Security Act, how does that play a part in this bill? Because I know a lot of people might hear those names and say, well, I don't know what that is. How does that represent today's, because obviously 1954 was a very long time. So how does that represent today's bill, especially within the UAP section and the whistleblower sections?
Well, those particular statutes are invoked by the executive branch because they have this long practice of invoking them effectively. And saying, so for example, one of the major issues that people are concerned about here is what the propulsion system is of these UAPs, the UFOs. And there's all kinds of discussion about it being 0-point energy or some sort of anti-gravity mechanism, et cetera. And the United States military has been wanting to find out what the answer to that question is, so they can use it to make weapons. and so what they do is they also say, well, okay, that's also energy. It's a form of energy. So we're going to put it under the Atomic Energy Act. In the Atomic Energy Act, the Atomic Energy Commission, for example, the AEC, that also deals with military uses of nuclear weapons material.
Right.
The minute you raise that stuff, everybody goes, whoa, wait a second. That's got to be super secret. We got to be extremely careful about it. And so that's what they're doing. They're basically flogging these statutes in front of us, saying, well, the same kind of, carte blanche security that we've given to all of these areas in the past, we want to bring them to bear again. It's just more of that response on the House side of limiting what it is that's going to be made available. And so what but I hasten to point out, the important thing is that that's not going to prevent the information from being given to the Senate Intelligence Committee. That's really trying to keep the information from being revealed publicly, because there's two different portions of the statute. One is saying that as much of this information as possible, it could be released in public announcements.
Right.
But there is going to be another area that is being kept secret. Okay. But then there's a third area, the one that you're referring to, has said that if the executive branch wants to take the position that they're not even going to reveal this information to the Senate Intelligence Committee, because it's part of some special access program.
Right.
If you want to invoke this kind of abracadabra, that, oh, this is part of a special access program, and that we're not going to reveal it even to the Senate Intelligence Committee, that we have to do everything in the world that we can do to keep that to as narrow a category as possible.
So that's one of their loopholes again. That's one of their
loopholes.
Right.
And that's what they've been doing. Everything having to do basically with the UAP or the UFO issue has been historically designated as a special access program. And that's why you could become the J2. You could become the head of intelligence for the Joint Chiefs of Staff, for example, Admiral Wilson, for example, and you aren't briefed in because you're not part of the special access program. So that they've got this huge caveat that they've got there for these special access programs that we have to do something about. We have to keep them from hiding as much of the information as they want to, because all the forces have never given up. Just because the New York Times has published this now in December of 2017, just because the Congress has passed this new statute, just because 60 Minutes is now, putting it on national television, doesn't mean that the people inside the intelligence agencies and security state people, they still don't want this information released. They want to hold on to this information, and very importantly, they want to use it to their own special advantage, for some sort of a weapons program. It's very frightening, actually.
I was just going to say, that's really scary.
Yeah, it's scary.
It's very, very scary. Then how do we create change in what's next?
So what we need to do is we need to target that particular provision, because it's such a red flag, as to where they're going to try to hide as much of this information as possible. And we're going to have to focus back on that. And we're going to have to develop at least some experiences with them hiding stuff in there that shouldn't be hidden. And then we're going to have to take that back to the Senate Intelligence Committee and say, look, you see, that's being abused. Okay. And then we got to get around to the House side with the Intelligence Committee and say, this particular provision that you put in there is being abused, and we've got to amend it. Now, the thing you need to understand is that just like you see, so people will keep this in mind, this whole debt ceiling debate that's going on right now, what you really see is that the extreme reactionary elements in the Republican Party are pushing back to demand that laws that have already been passed, that were passed under a Democratic House and Senate and a Democratic president, they want those rescinded. They're going back after them to say, please take money away from that program, defund a program that's already been funded, so we can reduce the debt. They never give up, both sides never give up. And so that what we're saying is the citizen side that has succeeded in getting this new bill passed and getting this office set up have to remain vigilant and active. And that's one of the objectives of the New Paradigm Institute, is to have a place for citizens to come, to be organized, to help focus in a coordinated way on what the problem is, what a particular concrete solution is. We have access to the people that are inside the Senate Intelligence Committee staff and in the House committee staff, so that we can target a particular misuse that's underway or abuse of a piece of the statute and move in to get it amended. You can amend any portion of this thing at any given time. Well, of course, the other side knows that too. And so that they're in full-time activity trying to restrict as much of this information as they can. So we have to realize we can't give up just because we've succeeded in getting this office together. A lot of people were going, "Oh, great, this is great. Now we can leave it up to the Defense Department and the Director of National Intelligence to just simply comply with this order from Congress." Well, the executive branch agencies have historically viewed the Congress as an adversary to their interests in trying to be professional, trying to keep things secret, trying to, mount a foreign policy, for example, that the Congress is too silly or too uninformed to really manage well. So
Right.
there's this institutional kind of antagonism inside the consciousness of a lot of the executive branch agencies against the Congress. And so they view it as a perfectly fair game to conceal as much of this information as they possibly can from Congress. And the problem is that the people that are in Congress, in the Senate or the House, have to get elected all the time again. And so that they'll only push so far as a rule. And a lot of times they'll pass a law and try to get credit for, okay, we've passed the law. We've gone along with you citizens that are all uppity and trying to make us do something that we didn't want to do. Okay, we've gone ahead and passed that law for you. And then they go ahead and don't pay any attention about enforcing it. And so that we have to remain ever vigilant here, especially those of us who are convinced that this is an extraordinarily important issue. We are the generation right now, or the 4 generations that are alive right now, that are actually going to be crafting the policies that are going to govern our relationship with a potential extraterrestrial civilization and species, for the next 10,000 years. All this is going to be done right in the next 10-year period. So this is an extraordinarily important time for our human family to stay focused on this issue, to not let the forces of the national security state and the intelligence communities and the weapons industry and all of those people continue to be as successful as they have been for the past 75 years. We've got to break this loose, and we've got to keep the momentum going forward to get at this information, even if it's primarily just to get it into the hands of the members of the Senate Intelligence Committee and House Intelligence Committee. It's a step forward, even if some of the information isn't being made public. We've got to get it shifted out of the executive branch, the national security state infrastructure, into the hands of the elected representatives, so they can at least make decisions as to how much should be revealed to the public.
It's still a tall order for 4 generations too, Danny. I'm like, and you're right, like looking at that, and I've never really thought of it that way, that in the next little bit, especially for other people's children's and the next generations to come, is when we're looking at any form of understanding what this is or any type of contact, we need to have that. I know exopolitics is obviously a conversation that people talk about, but looking at legislation first is so important, and how we go about dealing with this topic in the future. That's right. You talk about portals. And so, when you're talking about the people, Sean Kirkpatrick did mention in the last hearing that there would be a public portal, and he just briefly kind of mentioned it. Yeah. What happens when the average person, right, can submit information that's UAP based, or any type of experience, let's say, that's related to the phenomenon, and they send this to Sean Kirkpatrick and his team to analyze? What happens with privacy? What happens then? Is this a new form of public portal that is like a Project Blue Book, but now for our era? Like, what happens there, and what happens if that privacy is leaked? What do we do?
Well, this again, Chrissy, is the subject of enforcement guidelines. Right. What we need to do is be very aggressive about compiling enforcement guidelines addressing each provision of this bill, so that we can be very specific about it. As lawyers, that's necessary. That's why you have contracts, et cetera. And that we want to have enforcement guidelines for the executive branch and for the congressional committees. And we need to have, very importantly, the AARO office take these seriously. Okay. And as you heard Sean Kirkpatrick say in the comparatively inadequate hearing that we've had, the single hearing where he testified, where he kept saying that, look, our job, he said, is to get identified as soon as possible things that are not UAPs. Remember? And he said that's someone else's problem. It makes
Right.
it an SEP. He said
Right.
that little phrase. He said is once we can get it identified, even if it's something that Russia has or China has or some other private company has, if it's not a UAP, then it's an SEP. It's someone else's problem, and we just chuck it out. And so what he's implicitly saying is that he's agreeing to focus on this other category of things, that are but they don't want to refer to the reason they won't use the term UFO anymore is because UFO has become a noun.
It's
become a noun.
Yeah.
Everybody knows what a UFO is, right? Everybody knows what a UFO is. And said, but a UAP is something, it's just an unidentified aerial phenomena. We don't quite know what it is. It can be all kinds of things, so what they've done is they're trying to avoid the issue. They're trying to avoid the issue of the vast bulk of the people who are familiar with this area believe that these are vehicles. And most of the people believe they're from some extraterrestrial civilization. In fact, virtually all of the people that have been involved inside the government, engaged in top secret investigation of the UFO phenomenon, believe they're extraterrestrial. And they say so. I've been in the meetings where we talk about it, but the executive branch, intelligence agencies don't want to admit that. They don't want to say, they want to keep it as vague as possible. They want it to be anomalous phenomenon. They want it to, they want it to be basically an adjective describing kind of a vague thing instead of it being a noun, because everybody knows that the minute you start dealing with it as a noun, people are going to associate it not only with the UFOs from an extraterrestrial civilization, but they're going to associate it with ET contacts, of actual encounters that people, hundreds, thousands of people have reported seeing the actual beings that are piloting these UFO vehicles. And I can tell you, from having been in the meetings with the Inspector General's office and others, we're sitting there in the meetings, and all they want to talk about is the technology. How fast do these things go? How can they possibly turn these corners like this? That's going to be 600 Gs of force. And the minute you sit down, I said, look, you can talk about the technology of these things as long as you want, but you're going to have to come to grips with who's flying these things, and where are they coming from? And immediately, you get one of these, oh, please, don't raise that issue with us. And so that's going to be one of the major problems with this office. Virtually any communication that comes into this office, to Sean Kirkpatrick's office, where they are talking about an actual sighting of beings in these craft, or the craft landing and seeing beings, they're immediately going to put this into some kind of a category where they don't want to talk about it. They don't even want to cope with that at all. They're going to go right back and say, well, what did the machine look like? How big was the machine? How did it leave any marks? So that my personal opinion is that Sean Kirkpatrick finds himself in a very challenging political place in the nexus between the citizens who are getting at least some response from our congressional representatives and the national security state people that don't want to reveal this stuff. Okay. And so it should come as no surprise, it's kind of a political position that he's in. And so he's talking like a politician all the time now about, what he's up to. Whereas what you really need in that position is an investigator, a real investigator that's digging into finding out what is going on here.
What an investigator attached to him, within the program.
But the as far as I can tell, this is another very important thing for people to remember that are listening today, is that one of the fundamental problems is that at this particular point, it doesn't appear that Sean Kirkpatrick views his responsibility as getting this information. He just views his position as being kind of passive that,
See,
okay,
that's it. But he did say in the beginning that he wants Congress, and he was asking at the hearing that more of these stories and more of these experiences, or any contact or information, be sent to him. He keeps asking, and he does
but
plead that in the beginning of the hearing.
that's a passive role. I sure would like to have people bring this
It's a good
information
point.
to.
He's
Just
not
think if
actively
you
looking.
had a murder investigation, and the detective said, "Gee, I sure hope somebody comes and tells me who did this."
It's a good point.
I mean,
Yeah, it's a good
that's
point.
a very
Yeah,
big problem here.
yeah.
As far as we can tell, Sean Kirkpatrick, for political reasons, views his job as a completely passive job. That he's waiting for people to come and talk to him and tell him stuff, and then he's going to codify it and kind of put it together and then possibly pass it on to, and then he's going to have to deal with the onslaught of demand on the part of the agencies to keep it secret. And almost everything is going to get put into this hole of, oh, there's a reason why we want to keep it still secret. We don't want to tell anybody about this at all. We don't want to put in any report. This is an SAP, special access program thing, and they're going to try to get everything put into that exception. Now he knows that, and so what I'm saying is that you really need to have the culture of that office. That AARO office has to have a culture of being an investigative agency that is actually going out trying to get access to this information and figure out, not just like, well, how many people from the CIA are going to come forward and tell us that they've had this information for a long time? Well, what if they don't come forward? Nobody's going to punish them. There's no punishment for anybody who's got the information who doesn't come forward to tell anybody.
I was just going to ask you that. Can we bridge then into that was my next question, was talking about whistleblowers or anybody that is attachment to any programs from Area 51 to you name it. If they don't come forward, for example, like Bob Lazar, are they going to call Bob Lazar and ask him about his experience? And obviously, we all know that story, and everyone who follows this topic knows Bob Lazar's story very well. And recently, since it's had its own resurgence, will they ask him, and will they ask people like even Richard Doty to come forward? Was he acting alone with the CIA? Was he acting alone, or was he working with the CIA in attachment of doing a disinformation campaign to Linton Moten Howe and I'm just forgetting his and Paul Benowitz? So will these people, be able to? Do we have to put this in legislation so that they do have to come forward, or will they? What do you think is going to happen at that point within the future?
There needs to be additional legislation.
Right.
That this law has to be supplemented, that we have to put some kind of legal obligation on people who have this information to come forward to this committee. And we need to get legislation passed to put an obligation on the people in this office to go get this information, not just to sit there waiting for somebody to come through the door.
Right.
That they've got to be actively investigating this to get this information. And at this point in time, this particular legislation does not reflect that attitude. It's not an investigatory agency. It's a recipient of information from people who voluntarily decide they're going to come forward, and it does have the provision in it protecting the people who come forward, right. But it doesn't do anything to compel them to come forward. And it's taken away the threat of seriously punishing anybody who seeks retribution against them. They took away that legal cause of action that was in the Senate bill. So, you can see, little flags all over the place about what the insufficiencies are of the present legislation.
So there's no reparations for anybody legally right now that has been, working, serving within the government, have had some form of UAP experience that's been negative. We've seen that years ago. We've looked at insurance companies have awarded people money that have had some form of UAP contact, and they've actually won these cases. But what about the government now? Like, what moves forward next for all of these pilots and everyone else that's had extreme severe mental health related causes because of a UAP experience or anything else? Will reparations be part of that? And is that something which you guys are fighting for as well?
There are, a dozen major insufficiencies, with regard to this particular statute that got passed, primarily on the House side, and put into law. And we need to identify all of those, and we need to craft ideal supplemental legislation that can bolster those areas. So we need to do that. One of them is the potential reparations for citizens, for example, that have been retaliated against. It's perfectly clear that, for example, Richard Dolan in his kind of major work of that 2-volume piece that he did called UFOs in the National Security State, he has access to the internal previously classified documents showing that there were conscious campaigns mounted by the Defense Department and the CIA to basically excoriate private citizens, to destroy their reputation, to destroy their careers, to silence them, to do everything they could do to stop them from communicating to the public about the contact experience that they've had. And there's nothing in the bill that addresses all of that. There's nothing in the bill that for example, provides immunity to anybody who comes forward and admits that they were engaged in some sort of criminal activity to conceal this information of retaliation against people, et cetera. And so there's a major demand on the part of a lot of people inside the national security state infrastructure to have some sort of immunity if they're going to come forward and talk about what it is they've done, what it is they've known about, et cetera. And they don't want to come forward unless they've got access to some kind of immunity against being prosecuted for it. So there are a lot of things that are necessary to supplement this particular legislation. But at the present time, what we want to do is just give this a chance. It's got a 4-year sunset clause on it, but it's been operational basically from 120 days after the enactment of the statute on December 23rd of 2022. On basically April 21st, this office became operational. And that's why you saw the testimony from Sean Kirkpatrick that testified with Senator Gillibrand and the others, because that's when they were ordered to stand up the office. Right. And so that's when the 4-year clock started running. So what we want to do is have them have a year of operation to get a look at how the office is working, how forward-leaning have they become? Have they, despite the fact that there's no mandate that they go out and actively investigate any of these things, how much have they taken initiative to do that? Have they called anybody? Have they called Admiral Wilson? Have they called any of the people to say, here, come and talk to us? We're getting information. There's as of right now, all the indications are that they're basically sitting there passively waiting for people to come to them. And people, as I say, are afraid. They've got a long history of being retaliated against, anybody who's tried to do anything about this. And so that there's a whole setting in period that we have right now to see how this thing is going to function. And that's why the New Paradigm Institute is going to be, our first assignment is to monitor what is taking place right now. Who is it that are being interviewed? What is the process by means of which they're coming into the knowledge of the office, the AARO office? How many people are in the AARO office? How much staff do they have? What kind of resources are they going to be given? Are any of these budget cuts that are now being demanded for the debt ceiling, are they going to affect the funding of this particular office? There's all kinds of things that we need to know about, but unless you have a citizen's office that is specifically dedicated to monitoring this process, you're not ever going to find out what the answers to these questions are. And so that's why the New Paradigm Institute has been established.
So are private corporate companies allowed to work on special access programs?
Oh, yes. Oh, they clearly do.
Are private corporate contractors for the American government protected from the average person issuing a FOIA request to learn more about the information and the special access programs they've been working on? Is it a loophole that they can't be FOIA'd? Those private companies can't be FOIA'd.
That's right. They cannot be.
And why not? Why are they exempt?
Well, because they wanted to be exempt. Because the people that passed FOIA under all the pressure from public citizens that wanted to get access to government information, the government agencies pushed back. There are 22 specific exceptions to the Freedom of Information Act, and one of them is that if in fact there's a private contract and they believe that information is proprietary information that is owned by a private corporation, that cannot be revealed. And that's just one of the 22 different exceptions to the Freedom of Information Act.
But shouldn't we then be able to, if they're not sharing that information, shouldn't we putting that into legislation then for them to be able to then to be FOIA'd and have those conversations?
Yeah.
Yeah. So why hasn't that been done yet?
Because the corporations pay millions of dollars a year to pay for lobbyists to go to Washington, D.C., and now they actually give direct contributions to the legislative elected representatives under the United States Supreme Court decision in Citizens United. They believe that they have a First Amendment right now to make contributions directly to campaigns, and it's a major fundamental public policy problem we have in our country right now. That it's more general than just in this particular area, though it's very important in this area. But the corporations have multi-million-dollar public relations firms and lobby operations that stop the members of Congress from passing those kind of laws because they don't want to divulge this information.
So how do we go about changing that?
Citizen education. That's why that's another one of the major missions of the New Paradigm Institute here, of our Romero Institute. It's to educate people so that people become familiar with the existence of this statute. That's why it's important, this program that you're doing, to let people know that this National Defense Authorization Act has this particular provision that now has this new office created. Most people don't even know about it yet. So that's one thing, is get people knowledgeable about it. The next step is to get people knowledgeable about how it's functioning, so that the New Paradigm Institute lets them know through our monitoring how well it's functioning. What are some of the inadequacies of it? Then we need to provide particular pieces of legislation to supplement the inadequacies of the legislation. And we need to educate people about those pieces of legislation. It's hard work, democracy
it's a lot of
is
work.
hard work.
Yeah.
And a lot of people don't want to do the hard work. And so that's why 501c3 public interest organizations exist. You try to do a lot of that hard work for the people and then give them a simple solution. Here, support, Senate Bill 4503, and here are the provisions. And what we've got to do is get people excited about it, get people interested in this. And this is probably one of the most important and most interesting issues in the entire realm of public policy, is the issue of UFOs. It's got the highest levels of interest on the part of citizens. The people want to watch the shows about it. They want to find out about this. So our job is to assist them in bringing this information down from the simple kind of entertainment realm that has been in for so long, down into the practical public policy arena of saying, look, we're the generations that are going to be creating the rules and regulations pursuant to which our human species interacts with an extraterrestrial civilization for the next 10,000 years. So get with it. Get involved in this. This is an extraordinary. You sit and watch movies all the time and think everybody else is the hero. Be a hero.
Yeah. And you can partake in it. I 100% agree with you.
Absolutely.
Everybody can be a form of activism. It takes one person to make change. It doesn't have to be a group of people. Obviously a group of people help, but individuals can do it too. I truly believe that. My last question to you too, before we obviously run out of time and my battery, apparently my camera. My last question to you is, you're working with whistleblowers right now within the UAP topic, and allegedly I've heard it's been about 6 of them. Can you tell me where those whistleblowers are, what their backgrounds are, or careers? Are they government? Are they other people? And what are the conversations you're having right now? And what kind of work are you doing with them moving forward?
Well, we have to be a little careful about this, but most of the information that I have is because of my working with the people like Lou Elizondo, Chris Mellon, Carl Nell, others, including, Gary Nolan, and other, we're working together. The people that have been involved in helping to get the Senate legislation passed are familiar with a lot of individuals whom we've been meeting with in the past. Lou Elizondo has been quite public about a number of the individuals that he has interviewed. He had that entire program on the History Channel of Unidentified, I think is the name of it. So he's brought forward a number of those people that are fairly well known already. Some of those are the ones that have been brought forward. There are a number of others that you raised the question about the privacy, protecting the privacy of some of these people until we know that they want to have their information made public. There's nothing that prevents them from going public once they have gone to the committee, to the AARO office and given them the information. Now, the AARO office, I'm sure, is going to say, now look, you've come forward and given us information. We want you to be very careful now. We don't want you running around on the television telling everybody about this. We want to, so there's going to be some of that institutional safeguarding of their information. But it's just like, there's if you get subpoenaed by a grand jury and go in and testify in the grand jury, you can go right out on the courthouse steps and tell everybody what you said. But every time that they go in front of a grand jury, they say, now look, you've testified in front of a grand jury, everything is really secret about what goes on in here. But none of that's true. None of that's true, So what we hope is that we can get as much of this information revealed to the public as possible. Okay. Now, just in closing, let me say there's a conversation that goes on in these circles where I'm fortunate enough to be involved, at least tangentially, in some of these things, and that is this concept of what they call catastrophic disclosure. They keep saying all the time, these people that are on the inside that know a lot about what it is that's been discovered about the UAP or UFO phenomenon, they keep saying we have to be extremely careful not to allow catastrophic disclosure. And so I've been attentive to saying, exactly what do you mean by catastrophic disclosure?
It can mean many things.
What do you think? What do you think that means? I mean, I know I sat in the meetings with the Nixon Justice Department people in the Pentagon Papers case, and they said it's basically going to be catastrophic if you reveal what's in the Pentagon Papers. It wasn't catastrophic at all. I mean, it did help bring to an end the Vietnam War. And if in fact you thought that the further prosecution of the Vietnam War was in our national interest, you might have viewed that as catastrophic. But there's that we need to really explore what the people inside the governing structures view to be catastrophic information that they don't want revealed. And the irony is that we need to know what the information is ahead of time in order to evaluate whether it's catastrophic or not. And then we're going to have to make some decisions. Citizens are, and people in the Senate Intelligence Committee and House Intelligence Committee are going to have to make some informed decisions about what conceivable reasons might exist for not revealing to the public information that we have about this. Now, that's going to be very troublesome because everybody in the historical UFO community, has come to so distrust government institutions because of the bad conduct on the part of these institutions down through the decades, that there's some danger that they will overdo it and say, look, at whatever the information is that anybody has inside the government, let's get it all put right out in front of everybody all at one time. Now we don't know yet. We don't know yet what it is that they think is so catastrophic that they know. And I'm in a kind of a peculiar position because I have attorney-client relationships with people, of having been legal counsel for the Disclosure Project, legal counsel for John Mack, now legal counsel for Lou Elizondo. There are some things that I will probably come into possession of that they would try to invoke, attorney-client confidentiality. And I have to respect that. But they know perfectly well that my general inclination is to downplay the real catastrophic dimensions of any of that information. I don't believe that that's really true. So I need to exercise some judgment about that. But that's part of what the New Paradigm Institute is going to be also trying to develop some protocols, some principles to govern the rate at which this information is going to be revealed to the public. How are we going to do this? Is there any information in there that we think is going to have such devastating repercussions that it would be contrary to the public interest to reveal that? I can't at this point imagine exactly what that would be. Unless, for example, you find that all of a sudden we discover that our United States government and central intelligence agencies been engaged in direct negotiations with these beings, for 25 or 50 years, and that they've authorized them to kidnap our people and do experiments on.
Right.
If that got revealed, then nobody would have any confidence in our government ever again. I mean, that's the kind of thing they talk about. Well, what that is, they give a hypothetical. Well, what about that? They were just testing me to see what I thought about that. And I would say, I would think that that's heinous. But there's a lot of heinous activity that I've already publicly exposed about the government over the last 50 years, and the government hasn't fallen.
Right.
But it's true that there is a substantial diminution of confidence in the integrity of our government now, from when I started working initially, I did the case that established the right of journalists to protect their confidential news sources in the Supreme Court. Right. And ever since that time, I've been getting access to more and more confidential information and getting it revealed. The revelation of the Iran-Contra stuff, the fact that our United States government was running assassination programs, smuggling heroin around the world in Southeast Asia. We've revealed all of those secrets about the government. And in fact, I have no doubt whatsoever that has contributed to the diminution of confidence in our government. But that's part of the First Amendment, is part of the Constitution, is that we do not inherently trust or give over complete loyalty and unconditioned acceptance of whatever it is our governing institutions do. We're critical of that. We're careful about that as citizens. We've only delegated to them certain limited powers to do things, even though they would like to garner unto themselves the absolute power to do anything they want, and so that we're in tension with them. We know that. But up to this point in time, I think I've conducted ourselves rather responsibly in that area, and I don't anticipate changing. And I don't think that there's any evidence that is going to be completely devastating or catastrophic to the continued functioning of our government that is going to be revealed in the information that they've concealed. I could be wrong. They could surprise me even after 50 years that they've been doing something worse than I've already discovered. But they probably assume that I'd be inclined to tell everybody about it. And I'll just have to make that decision when the time comes, if it comes.
Thank you so much, Danny, for joining me on Rebelliously Curious today. And as I say to my guest, thank you for being so rebelliously curious with me.
Well, you're more than welcome. It's a privilege. Thank you.